Hi, everybody. Welcome to week 8 of our course. So, on tap for today, we're going to review briefly some of the things that were covered last week regarding the adjudication of criminal cases in the American court system. Then, we're going to talk about adjudicating civil cases and think about how the American legal system is designed to deal with these types of cases and to what degree adversarial legalism affects the process. And then finally, I will discuss the midterm, which is taking place in class next week, October 24th at 6 p.m. All right. Okay, so we talked about this last week, but the incarceration rate of Americans has steadily increased over time, and then starting in the early 1980s, it has skyrocketed. And so, one of the or some of the reasons behind this are the due process revolution, which we talked a little bit about in class with the Warren Court in particular, law and order politics waged by the Carter and Reagan administrations on into the first George Bush administration and the Clinton administration as well. And also the war on drugs, which was initiated by the federal government and largely in response to the crack cocaine epidemic that plagued American cities starting in the late 1970s into the 1980s. So the result of this is that we have a more active criminal justice system than other countries do, and a more active system than we ever have before. And this should sound familiar because it echoes some of the things that we talked about with respect to adversarial legalism. And so I want you guys to keep thinking about how to apply adversarial legalism to the organization of the American court system, how the American court system has changed over time, adjudicating criminal cases, as well as adjudicating civil cases. So, as we talked about, criminal trials in the U.S. Often take a very long time, and they're often um, set up in many ways sort of against the accused right from the very beginning, despite the fact that we have a system in which criminals or people who are accused of a crime are innocent until proven guilty. The four stages of criminal trials that we talked about in class, the first is the actual commission of the crime itself and the arrest. We talked about how most crimes are never solved and most criminals or most people who committed those crimes are never charged. And there are a lot of reasons as to why that is the case. There can be distrust of the police, there can be a reluctance on the part of victims to deal publicly with their accusers in terms of testifying at trial. Many victims are in ongoing relationships with their with the accused, and so for all of these reasons, it can be really difficult for cases to be solved and for people to be charged. Next, we talked about the charging decision by the prosecutor, and the prosecutor, again, is a public official, so normally a district attorney, or in bigger cities, bigger jurisdictions, you have a whole fleet of assistant district attorneys who are involved in charging decisions as well. A large number of cases are never prosecuted, and this is because cases are plea bargained, etc. Then we talked about the setting or the denial of bail, and bail was put in place to ensure, again, in a system where people are innocent until proven guilty, it was put in place to ensure that people, after being accused of a crime, will show back up for their trial. Posting bail can be considered punishment before trial because it often, and this is not hard to imagine why, but it often affects people who have fewer resources, one-shotters, if you will, than people who have a greater amount of resources. And then finally, we talked about the indictment by a grand jury or other procedures. So talked about what a grand jury is. It's a group of people, 23 people for federal crimes. It varies at the state level. Indiana, for example, has 6. Texas grand juries vary in size, but they play a role in the process because it's not up to them to figure out whether or not an accused is innocent or guilty, but rather it is to look and see whether there is sufficient evidence to charge the accused with a crime. And then finally, we talked about plea bargaining, which is another sort of alternative procedure that happens a lot before trial. And this is where the prosecutor and the accused and the attorney for the accused strike a deal, right? And so it's often a lesser sentence in exchange for a guilty plea. And we talked about whether or not this promotes justice. And much like settlement, which we'll talk about with respect to civil cases here in a minute, it's got its pluses and minuses, right? So on the one hand, it leads to a greater number of convictions, which in our system, prosecutors are often praised for a high number of guilty verdicts. It can also potentially lead to a system of particularized justice, right, where both sides feel as though the accused in particular is being dealt with in a way that fits the facts of the case. On the other hand, though, it may not actually promote justice because they don't actually go through the process of a trial. The evidence is not submitted, and thus you can see that the accused, or the accusers rather, feel like they don't exactly have their day in court. So we also discussed some policy issues in criminal justice, in particular the exclusionary rule, which, as we mentioned, forbids the use of any illegally obtained evidence in the course of a trial. Supreme Court decision Mapp versus Ohio extended the exclusionary rule to the states. And in many ways, the American criminal justice system has been reacting to this rule ever since it came down during the Warren Court in the mid-1960s. It was assailed by critics as making America soft on crime, and so many of the punishment-related policies that we've seen since then have sort of been in reaction to this. We also talked about the insanity defense, which after 1984 changed a little bit. Now the defense has to prove that the accused was insane at the time of the crime, rather than the government having to prove that he or she was not. And finally, sentencing. There's been a lot of discussion, there's still a lot of discussion actually in the Jeff Sessions Justice Department about rehabilitation and whether or not it works versus mandatory minimum sentencing, as well as sentencing guidelines versus sentencing reform. And then finally, one of the other big policy issues in criminal justice is drug courts. And here, of course, we're talking about the war on drugs, which I just mentioned in the last slide, and this idea that we can incorporate treatment for substance abuse into the judicial process. And then finally, we talked about the Caleb Foote article regarding vagrancy laws. And of course, this was Caleb Foote's attempt to sort of inject legal realism into a discussion about how criminal courts in America work. And the time in which he was doing this research was the early 1950s. He was doing it in Philadelphia. And rather than reading trial transcripts or interviewing people after the fact, he went down to the municipal courthouse and simply observed how trials were working. And so he sat in on hundreds and hundreds of vagrancy cases and often interviewed the participants after trials were over. And what he found was pretty disturbing. On one day in particular, he found 55 cases that were dealt with in 15 minutes. And this was a big policy problem all across the country, not just in Philadelphia. There were 100,000 similar arrests in Los Angeles, 50,000 in Chicago, 40,000 in Washington, D.C., etc. And so one of the things that I want you to remember from this discussion is that here we're really talking about this sort of expert political model of legalism, right? So the upper left quadrant of the adversarial legalism typology, which of course is Robert Kagan's design. And this, as we've talked about many times in class, is not a particularly good place to be if you are accused of a crime, because your rights and this kind of formal idea of judges and everybody involved in the process having to follow rules that are clearly laid out and clearly designed, that really goes by the wayside. So it's hierarchical, judges in charge, but not based on precedent. And in fact, most, if not all, of these accused vagrants did not have legal representation. So judges ruled their courts often by whim with an eye towards self-aggrandizement. And so it was a large part because of trials like these as the due process revolution got going in the 1960s under Earl Warren that America ended up changing its vagrancy laws to now, at least by design, protect the individual rights of the accused, right? And of course, in this old model, in the expert political model, the law really plays very little or a very small role in the proceedings. So the takeaways here are that the decentralization of authority has meant that a lot of institutions, laws, and practices have developed for dealing with criminal justice issues, and that these institutions, laws, and practices are often at cross purposes with each other. So you have legal standards and discretionary practices that are diverse. Rules that regulate pretrial release vary from state to state. The rate of dismissing charges varies from court to court and state to state, as does the rate of plea bargaining. And so you put all this together and you realize that adversarial legalism is more present than ever in the American criminal justice system, which is decentralized yet formal. And by decentralized, of course, I'm talking about the internal organization of the criminal justice system as well as its reliance on parties rather than judges. And finally, questions of law in America inevitably become questions of politics, as we've seen with the response to the due process revolution. All right, so moving on to the subject of today's lecture, which is adjudicating civil cases. So as we talked about, criminal law is the prohibition of certain conduct and threat of punishment by the state, right? So the state, and here, of course, we're talking about like a state like Texas or the federal government and a federal crime, is one of the parties to the case, right? So you have the accused and you have the state. And so here we're talking about cases like murder, battery, drug possession, etc. Civil law is a little bit different because it involves everything else, and the state can be a party to a civil case, but the punishment does not center on the loss of freedom or incarceration. Instead, it centers on compensation of the plaintiff. And in a civil case, it is the plaintiff who files a lawsuit, and it is the defendant who is responsible for responding to the lawsuit. And here you have examples like wrongful death, breach of contract, tax disputes, etc. It's important to note that the same cause of action can lead to both a criminal trial and a civil trial, although these trials do not happen concurrently. An example of this is the O.J. Simpson trial in California in the mid-1990s. Of course, he was famously acquitted of murdering his ex-wife and her friend, Ronald Goldman. And so even though he did not go to jail for these crimes, as soon as the criminal trial was over, the parents of Nicole Brown Simpson and Ronald Goldman filed a civil suit against O.J. Simpson in Los Angeles courts, where they said that he was nevertheless responsible for their deaths. And in that civil suit, the jury found that O.J. Simpson was monetarily responsible for their deaths and was ordered to pay compensation to both families. So we're left with two puzzles then. Do we have more civil law now than before? And do we have more here than there? Again, these two puzzles should sound very familiar to you. And the bottom line, which we'll come back to at the end of this discussion, is that the U.S. is a very litigious country. That means that we are willing to file lawsuits. That's what litigious means. And that, of course, as you know, we frequently use courts to address significant social, economic, and political issues that other countries address via legislatures and bureaucracies. And we'll talk about that in the context of civil cases as we move along. So let's get a brief timeline on the table of how a civil case works in the American court system. So first, a complaint is filed by the plaintiff, and the complaint here is normally filed in district court. It can be at the state level, or in Texas, the county level. Can also be filed, though, as a civil federal case in federal court. The defendant then can either default, which is they never answer the lawsuit. So if you've heard of like a process server, for example, they're the people who are in charge of going to find defendants and serving them with the lawsuit. If the defendant never responds, a default judgment is entered that normally just simply finds in favor of the plaintiff. The defendant can also answer the lawsuit. They have a certain amount of time to do so. They engage an attorney. The attorney reviews the lawsuit and files a response. In this response, or after this response, we'll talk a little bit more about what happens, but both sides normally engage in what we call pretrial discovery and motions. And I'll get into the details of pretrial discovery here in a minute, but it normally involves, on record, the production of documents by the defendant and by the plaintiff, as well as the answering of questions. And these questions can come in the form of what we call in Texas interrogatories. These are questions that defendants usually have to provide a 1 or 2 sentence answer to. Also, requests for admission. These are considered sort of yes or no type questions, true or false questions, as well as what we call requests for production. And this is where the defendant has to produce documents like emails or some other kind of paperwork that may be germane to the case. Next, we have pretrial conferences. And this is where both sides are encouraged to meet with each other, what we call alternative dispute resolution. I'll talk more about this in a minute, to try and come up with a satisfactory result before the case has to go to trial. And here is where settlements often take place, and I'll talk more about that later. Next, of course, is the trial itself, and this is where both sides normally engage expert witnesses who testify under oath. And then once the trial is over and a judge or jury has ruled either in favor of the plaintiff or the defendant, the losing side can file a post-trial motion that can lead to an appeal. And then the appeal means that the case would go up the ladder. There are a lot of reasons why some lawyers would want to file an appeal in the face of an unfavorable verdict. There are also many reasons why lawyers do not end up filing appeals, namely because the legal process for many plaintiffs and defendants is quite expensive, as we will talk about. And then our final step in this process is the enforcement of the judgment. And this, as I'll talk more about in a second, can involve, usually it involves money, but it can involve sort of forcefully demanding that the defendant give the plaintiff money. This is can be through the garnishment of wages. I'll talk about that in a second. So going through these one by one with the filing of the complaint, one thing that the lawyers have to think about is the jurisdiction. So which court is proper for the case and which court can actually hear the case. You also have to think about causes of action. So in the filing of a lawsuit, you have to demonstrate as a plaintiff's attorney that your client was in some way harmed, usually monetarily, by the defendant. And then you have to ask for a prayer for relief. And this usually comes in the form of damages. So you say, look, because of this case, my client, the plaintiff, lost X amount of dollars. We request that the court order the defendant to pay the plaintiff this money, as well as covering the attorney's legal fees, etc. And we'll talk about some legal fee arrangements here in a second. So once the complaint is filed, the defendant can, as I mentioned, either default or answer the complaint. Usually defendants deny allegations in a general sort of way and wait for specific denials later on once they see what the plaintiff is going to do in response. Oftentimes, though, defendants list what we call affirmative defenses, and here these can involve counterclaims. And this is essentially where plaintiff sues a defendant responds by denying the allegations, and then, in a sense, countersues the plaintiff. So after this happens and the defendant enters an answer, we go through the process of pretrial discovery and motions. These can include motions to dismiss, and these are filed by the defendant, right? So it doesn't make any sense for the plaintiff to dismiss his or her own lawsuit, but the defendant can claim that there's no cause of action or potentially no legal remedy to solve the problem. The defendant can also file a motion for what we call summary judgment. Lawyers, if you work in a law office, you'll often hear these called MSJs. And this is where usually it's the defense, but the defense can claim that there's no genuine issue of fact here, essentially that the plaintiff does not have the information needed to file the lawsuit, and the court, usually a judge, in fact, can then dismiss the lawsuit. They can also, as I mentioned when we were talking about the timeline, they can subpoena documents, and in Texas this happens via this process of request for production, often called RFPs. And then they can also take depositions, which are on record interviews in front of court officials, like a stenographer, for example. And I used to work, I think I've mentioned this, but I used to work at a law firm in Dallas before going to graduate school. And whenever our clients, who were usually plaintiffs in these cases, they would often be deposed by defense counsel. And these depositions would often take place um, in our actual office, and they could be really emotional. So we dealt with some pretty disturbing cases. In one case, a little girl cut her finger off with a pair of safety scissors at daycare. She was 3.5 years old, which is pretty horrifying. And we ended up suing the daycare. We ended up suing the scissor manufacturer. We were going after $1 million insurance policy that the daycare had. And the defense attorneys seized on the fact that this little girl who was our client, her parents were going through a pretty acrimonious divorce at the time. And so they deposed this girl's mom in our office and brought up the divorce, and she got very angry and tears were shed, and they were essentially implying that the little girl had cut her finger off on purpose because of her parents' divorce. So these depositions, I'm sure you've all seen, taped depositions before. They can be pretty emotional. So then the process of pretrial conference starts. This is where both sides deal with scheduling issues, scheduling trials, and all of that kind of stuff. This can be used often for the defense as a delay tactic. And one thing I should mention here is that plaintiff's attorneys are often paid on what we call a contingency fee arrangement. And this is where, as a plaintiff's attorney, you do not get paid unless your client receives money, right? So a defense attorney charges by the hour. And a really good defense attorney in Dallas or in New York or San Francisco or wherever could charge upwards of $1,000 an hour for their fee. And so, like in our daycare case, for example, the defense attorneys were charging the daycare company, were charging the scissor manufacturer, were charging the teachers, all of whom we had sued. They were charging them by the hour. On the other hand, the attorneys that I worked for had engaged in a quote-unquote contingency fee arrangement with our clients. And usually this means that when a case settles or a judge or jury sets forth a monetary award, the plaintiff's attorneys take somewhere between 25 and 40% of the award as a fee. So we'll talk a little bit more about that in a minute. So the final parts of the timeline include the trial. We'll get into trials here in a second. Post-trial motions, asking the judge to reconsider the verdict, and then the formal appeals process, as well as judgment enforcement, which, as I mentioned, can involve the garnering of wages, etc. So the upshot of this is that the process can take a number of years, and it clearly demonstrates that adversarial legalism is alive and well in the civil court system in America. The process is costly. The process is expensive. The process is in many ways inefficient. And the process is driven largely by lawyers. And these lawyers are adhering to formal rules and procedures, which makes this different than arbitration or mediation. But nevertheless, it's the lawyers who drive the action in this process. So let's now apply civil cases specifically to adversarial legalism. So U.S. trials generally take years to complete, and not the trials necessarily, but the entire legal process. A trial doesn't normally take years to complete, but the entire process can often take years, compared to places like Germany, where legal proceedings are often over and done with in a matter of months. So U.S. trials, as I mentioned, are very expensive. They are often unpredictable for reasons I'll get into in a second. Judges can undo the work of juries, which makes them seemingly less responsive. And finally, judges' ideologies rather than the law can often significantly influence cases. So why is this the case? Why are these sort of adjectives used to describe the American court system? So let's cover both of these, the costliness and the unpredictability of civil court cases in America. So one of the reasons why cases are so expensive in the American judicial system is that we have all-at-once trials. And this is where everything from matters of fact to scheduling issues, et cetera, are all taken care of during the course of a trial. So the process is not like a rationalized bureaucracy where certain courts deal with certain parts of a trial. You could imagine sort of an assembly line process of civil justice that may make this process a little bit more efficient. Juries and the voir dire process, and voir dire is the selection of juries. This can take a really long time. Cases are often really complicated, especially in like intellectual property, for example. They can be dealing with some really technical scientific issues. And keep in mind that a jury, up until, they're of course sitting impaneled on a case, they don't have any special training in these issues. So it's up to the plaintiff's attorney and the defense attorney to sort of educate them. This process can take a really long time and it can be very expensive. And then finally, lawyers, at least defense attorneys, are paid by the hour, thus giving them financial incentives to make a trial last longer, right? So you can imagine if a trial or if a process takes 3 months versus 6 months, the 6-month process, your client may be upset if you're a defense attorney, but you as the attorney are going to get paid double what you would get paid if the process took half as long. Cases in the American civil judicial system are also quite unpredictable. So juries are a big-time wild card. They can vary from jurisdiction to jurisdiction. So if you're a member of the Texas bar as a plaintiff's attorney, and you have the choice of filing a case either in, let's use Collin County, which is where Plano and Frisco and McKinney are, versus Dallas County. Dallas County is seen as a much more favorable venue for most personal injury cases. And this is due in large part to the demographics of the type of people that sit on juries in Collin County and Dallas County. So Collin County is often seen as very pro-business. And this makes sense. It's an affluent population with a lot of people who work in business settings, right? And so when they sit on the jury, or when they sit on a jury, their sort of natural inclinations, right? How they identify themselves as people, they may be more likely, more prone, even if they're not sort of cognizant of it, even if they don't know that they're doing this on purpose, they may be more likely to side with business rather than siding with the plaintiff. Dallas County may be the exact opposite. There are also courts in Southeast Texas, for example, in which asbestos lawyers, we'll talk a little bit more about asbestos later in the semester, but asbestos lawyers got really, really rich from filing these asbestos personal injury cases in courts in Southeast Texas that were often seen as very favorable to workers and not favorable to industry. And then finally, cases in America are often unpredictable because of entrepreneurial lawyers who are always testing the limits of what can and can't be heard in a civil trial. So the takeaways here are that there is a huge amount of settlement in the American civil law system. I'll talk more about that in a second. And this settlement has some real benefits and it has some real drawbacks. And a settlement is where, much like plea bargaining, it's where the plaintiff's attorney and the defense attorney get together before a trial happens, or often in the middle of the trial, and decide together to settle the case for, so they don't have to go through the process of having a trial. There are some benefits to this and there are some drawbacks to this. So a benefit to a settlement is that there's an agreement between the parties. And so here we can see mutual accommodation coming into play. Both parties consent to the settlement, thus giving it more legitimacy, and of course it's cheaper. And if you think about it in terms of some of the things that we've talked about earlier in the course, this is actually a form of self-help in which the parties can tailor the outcome to the individual merits of the case. There is a high degree of legitimacy for both sides, and of course, it's faster and less costly than going to trial. The drawbacks of this are that when both sides are bargaining in the shadow of the high costs and high levels of uncertainty of adversarial legalism, um, that justice and the law, and especially settling the law, is often lost, right? And so the law takes no, does not really take center stage here, and instead, both sides are driven by the economics of sending a case to trial rather than by questions of guilt, questions of fact, questions of law, etc. And so, just to bring the discussion back to that case that the lawyers that I worked for heard with the little girl and her finger. So, each side took numerous depositions. The attorney that I worked for flew to California to depose the scissor manufacturer. We deposed several of the daycare teachers in our office in Dallas. We deposed the owners of the daycare. And as I mentioned, the other side deposed the little girl's parents. And so after all of that, we had a trial date on the calendar. And after all of that, rather than go to trial, the lawyers that I worked for decided to settle the case a few weeks before trial. And as I mentioned, the little girl had cut off part of her finger from safety scissors. In fact, it was about a third of her left ring finger. And we settled for about $400,000. So because she was a minor, that money would then go into a trust fund that would be administered to her once she turned 18 years old. So it was a really interesting decision by the guys that I worked for to settle this case. Their big sort of prize in the case was $1 million insurance policy that the daycare held. And so the idea is we would go after that $1 million. The daycare could then stay in business because that's why you have insurance, to help pay for things like this. So it sort of begs the question, why didn't we go to trial and why didn't we seek the full $1 million? Well, the lawyers that I was working for were engaged on a contingency fee basis with this family. So the idea was that they would get, I think it was 33% of any settlement. And so here you have lawyers who are really concerned about the law, but instead they're weighing the economic risks of going to trial. Because if we had gone to trial, the jury could, they probably wouldn't have because we had pretty favorable facts in this case, but the jury could have come back and said that the daycare company, the teachers, and the scissors manufacturer were not liable at all for the little girl cutting her finger off. And if that had been the case, then the attorneys that I worked for would have worked on this case for a year, and they would have, scheduled these depositions at great expense to themselves, spent a lot of time on it, flown to California for these other depositions, prepared for a trial, etc., and then had literally nothing to show for it. And so rather than run that risk, they just decided to settle for $400,000, which meant a pretty good payday for them. They received over $100,000. And of course, our clients were reasonably happy with it. The little girl who cut her finger off, she received $300,000 that would then be administered to her once she turned 18. So it was a sort of mutually accommodating decision. But at the same time, we live in a system of common law that is built on precedent. And so if too many cases settle, then these questions of law are never settled, right? Are never dealt with at trial. And so it's just a self-reinforcing system. It leads attorneys to settling more, et cetera, et cetera. So one of the other pieces of assigned reading for this week in class was this New York Times article on the development of arbitration. And you can sort of think of arbitration as being in the bottom left quadrant of Kagan's 2x2 typology. But it's not quite as informal as mediation is. In fact, it can be a pretty formal process, yet is what we consider a system of privatized justice. And procedures like arbitration were put in place because of the skyrocketing costs incurred by both sides, plaintiff and defense, that both sides incur by proceeding through the American legal system. Yet they have the effect of privatizing justice in a whole host
of areas. So medical malpractice, sexual harassment, hate crimes, discrimination, etc. And you often see arbitration um, being the avenue that plaintiffs have to proceed through when it is a complaint from an employee levied against his or her employer. So oftentimes, and some of you may have done this without even knowing it, but oftentimes when you sign a contract to work at a place, buried in the fine print of that contract is you agree that any disputes that may arise between you and your employer, rather than being dealt with in the American legal system, are instead dealt with in this process of arbitration. And so arbitrators are often former attorneys who are engaged by the defense, so by the employer or by big business, to deal with these cases. And essentially, it is a system of privatized justice that tends to favor businesses. And again, if we're applying these sort of concepts that we talked about much earlier in the class, like the logic of the triad, for example, the logic of the triad is built on impartiality by the judge, right? And we know, of course, that the logic of the triad doesn't hold once the judge sides in favor of one plaintiff or in favor of one party over another. But nevertheless, it's really important for the rule of law for judges to maintain this sense of impartiality all the way up through siding with one party or another, right? And of course, this is why our courtrooms are so formal. It's why judges sit up high. It's why they wear robes, etc. We've talked about all of this stuff. So if you think about arbitration as sort of being skewed in favor of business, that triangle, which looks pretty even, the logic of the triad triangle, in the system of arbitration, it's not even at all, right? So the person who assumes the role of the judge, the arbitrator, has been accused, at least, of often leaning towards the side of big business before a trial even starts. So our big takeaways here today are that adversarial legalism tends to provide considerable formal protection of individual rights. In practice, adversarial legalism is costly and unpredictable. As a result, the majority of civil cases are settled before they ever go to trial. This means that outcomes are divorced from the law, and the emphasis is on bargaining power and economics rather than the law itself. This can undermine common law process and can really hurt this formulation of the logic of the triad. And all of these cast doubt on the promise of adversarial legalism to resolve disputes under the law in an orderly manner. And this, of course, is the first promise of the law, which we talked about in day one of the class. So hopefully this discussion of civil law in America sort of brings us back full circle. So I want to spend a few seconds talking about the midterm. I covered this slide in last week's lecture, but the midterm is taking place on Tuesday, October 24th. 6 to 8:50 p.m. The test will be designed for you to be able to complete within that time frame. It'll be a blue book style format, which means, and for those of you who've not ever taken a blue book test, a blue book is simply a collection of sort of loose leaf notebook paper that is bound together in a little booklet that has, no surprise here, a blue cover. It's going to be a mix of identifications, a series of short essays, and a longer multi-part essay question. It'll cover parts 1 and 2 of the course. I'll get into the specific content here in a second. I will post a review sheet today that will include a list of terms that the identifications will draw from, as well as a list of questions that the short essays and the longer multi-part essay question will draw from. So all of the components of the test will be on the review sheet. If it's not on the review sheet, it will not be on the test. So this test is not meant to trick you. It's not meant to throw you a curveball. It's meant to be, it's going to be challenging, but it's meant to be straightforward. So, this bullet point is from last week. So obviously in these slides and this YouTube video, I will have talked about the midterm. So, one thing I should mention too, in these identifications, so you'll have to answer, I don't know how many just yet, but you'll have to answer, let's say 7 or 8 of them, something like that, maybe up to 10, I don't know. But on the identifications, you need to do 3 things. So you need to define the term, right? So if you're using adversarial legalism, you would want to define the term.
You'd want to talk about how it was a 2x2 typology designed by Robert Kagan that allows us to compare legal systems in different contexts. And it's organized along this um, sort of continuum of hierarchy on the left and rules centered on the bottom, meaning the y-axis, and et cetera, et cetera. And then the second part of an identification is you need to talk about the significance of the term or its relevance to the course. And so for adversarial legalism, you would mention that this is one way of giving us sort of a framework to look at the American legal system in context, right? To look at how it's changed over time and to look at how it differs from courts abroad. And then the third part of it is you need to give an example of the term. And you don't always have to give an example because, in a sense, some of the terms themselves will be the examples. But you would need to talk about how, for example, with adversarial legalism, you see echoes of it in the civil law system or in the criminal law system or whatever, right? Okay, so the big concepts that the test is going to cover, we're going to cover the two promises of the law, right? So orderly dispute resolution on the one hand, and making policy or correcting policy failures on the other hand. These will include the concepts of self-help and the logic of the triad, which again is Martin Shapiro's term, and it's this idea that our justice system is sort of predicated on the idea of having a neutral party hear a dispute between a case. It's the opposite of self-help. The logic of the triad works pretty well right up until the judge decides in favor of one party or another, at which case, oftentimes for the party that loses, the legitimacy of the triad is compromised. The test is going to cover Rosenberg's dynamic court view and constrained court view. So here I would urge that you go back to that table that we covered last week and the week before and the week before that, where we talk about these specific constraints, right? So doctrinal constraints, institutional constraints, both internal and external, and cultural constraints, as well as the core metaphor that the DCV employs and the core metaphor that the CCV employs. So the core metaphor with the dynamic court view is that our courts belong to this sort of decentralized separation of powers sort of idea where the courts are able to rule pretty effectively despite the fact that we have an executive and a legislative branch. Constrained court view, the core metaphor is this principal agent idea, which is that the courts should essentially just do the bidding of the elected branches. And then finally, you need to talk about the implicit conception of politics that both the DCV and the CCV employ. So for the DCV, it's a little bit nebulous, but it's the idea that the court is particularly helpful at placing items on the public agenda. And so even though, yes, after Brown versus Board, schools were still segregated, 15 years later, 20, 25 years later, the courts were pretty effective in Brown versus Board at getting the discussion of these rights to be placed on sort of the American menu of policy options. The constrained court view takes sort of a stricter approach and says, look, if we're going to argue that courts are effective policymakers, then we need to measure policy outcomes after these big decisions and see if the courts actually made a difference. And so that, of course, is where they criticize Brown versus Board. You also need to understand how the American legal system at the state level in Texas and the federal level is organized, how it has changed over time, and how it differs from systems abroad. And here, of course, you'll need to apply the lessons of adversarial legalism. You'll need to understand what each of the four boxes in the 2x2 typology means. You'll need to understand on which continuums we measure this typology, so hierarchy and precedent. And then finally, you need to understand adjudicating criminal and civil cases, which is really putting adversarial legalism in action. We'll continue to do that in part 3 of the course, but right now we sort of introduced it with this discussion of criminal and civil cases. So one final thing, my office hours next week, I'll have office hours on Monday from 12:30 to 2:30. I will not be on camp, and I have office hours on Wednesday of this week from 12:30 to 2:30 as well. I will not be on campus Thursday or Friday, but I will be able to answer any questions that you have via email. So again, be on the lookout for the review sheet. I'll post it on Blackboard along with an announcement later today. And good luck studying as we proceed to the midterm, and I will see you all next Tuesday. Thanks a lot.